My friends, I'm sorry to rush us through our coffee, but I thought what I'd like to do is to make sure that we have time for one of the two purposes of this conference. One of the purposes, really inspired by Roger Gardner in Veracruz about a year ago when we had our first TIES organizational meeting. Roger Gardner gathered us together and described a horrific situation in Mexico with a bit of a plea. And the plea was to the TIES partnership, first, try to understand what's going on in Mexico, and then help. Don't just talk about it. Don't just be academics, but see if you can figure a way to help. And so when we went to him and said, well, how about in about a year we gather as TIES partners after about a year of work, what we'd like to do is to have a chance to talk to each other about how we're working, and also as new partners come on, we'll have a chance to share ideas and find out what's working, what's not working, what we can do better, what questions we're running into. Of course, the other purpose is to learn about what was being done outside of our efforts, our individual efforts, in our silos when we're working with our partners, what else is going on. And I think that we have learned tremendously this morning that there are lots of efforts that are going on in lots of different areas. And so I don't know about you, but I feel like I am greatly assisted by this new information, and in some ways I'm spinning. And what I would like to do as we go through our presentations, partners, if we can, to think about with me a couple of issues that we've learned from the conference. And if we can, as we talk, if we can signal what your reactions are to some of the issues that we're learning about, then it seems to me we'll be using this time in a good way. So I'm going to just give a couple introductory ideas, but then go ahead and turn it over to the partnerships, and if you'd think about a couple of these issues as we're going along. One is, as you know, it's a classic cart-horse problem, and that is what we are asked in part to do is to respect the culture and to make sure that we're not making things worse. And of course, as Americans are wont to do, we come in, you know, with our ties and shirts and say, here's how we do it. And there's an arrogance to that, and very often it seems to make things worse. We heard this morning that, in fact, there's a resistance where people will come up afterward and say, well, we don't do it that way. So we've got that issue. And then we have the issue of, but what we hear from our Mexican partners is, we need change. Things aren't working. So we want you to respect the culture, but by the way, we want change. And we want change, fundamental change. Right? And so in some ways there is a cultural message there that is, okay, to what? Change to what? Well, you say there's a new constitution that says there's an oral adversarial system that is what we'd like. We want to try it out. We think it's going to help us with corruption. We hope it helps us with transparency, but please make it efficient, right? And make it very respectful of the way that we do things. So there is a fundamental, then, question for an educator, which is, how do I help without hurting when, in some ways, the whole project is developing as to what it is that the competencies are, what the skills are going to be as the system learns more and more about what it's going to do. So those are the challenges, as I hear it, to our projects. And there's a great amount of hope that, in fact, in educators coming together with professionals. And you know, there's always this risk also of professional insult. The lawyers get out there and say, well, professor, what do you know about it? And there's the professor that says, well, what do you know about education? And there's this, we've got to be careful as we go forward. And the judges say, what do you know about what goes on in my courtroom? And so what we have is we've got to be very careful also to realize our audience is easily offended as we even talk to each other about what our ideas are. And so that's a challenge also in the way that we conduct ourselves. And if we come in too heavy-handed, we may be fighting with our audience as they're dealing with maybe their sense of being left out. I've been doing this for 30 years. Why didn't you call on me? And so there's an initial resistance to even what you're putting out there because, you know, there's an insult to the person who is listening, and we've got to deal with those kinds of issues also. So it seems to me those are some of the early issues we've got to talk about. Frankly, I hear a couple fundamental discussions to have, which is how much does the change to an oral adversarial system change also the civil law approach to law and the common law approach to law? All right? How much is implicated in a change to oral adversarial system that really is we need to adopt a fundamentally different way of looking at the law, where the law comes from, how it is that you gather the law, information about the law, and how you use the law. Let me give you one quick example from this morning. For example, when you say that you use a ADR system, a system of alternative dispute resolution, what that means in a common law system is the ADR system is disciplined by what happens in the courts. It's disciplined by what happens in the courts. But the only way you know what happens in the courts is if you have a very fundamental reporting of what's going on in the courts. The system has got to have a way for the courts to report in a fundamental way what the evidence was that was considered and not considered, whether it was going to be admissible or is not going to be admissible. And without that discipline, then in a common law situation, ADR is a kind of lawless justice. It has no law that's associated with it. It's just whatever it is that's going on, and therefore there's no learning that's going on from it. But if law really doesn't depend very much on what's going on in the court and capturing of that, then if it's in reference to a series of civil codes or statutes, then ADR could still be disciplined without a real vigorous court capturing of what it is that's going on. So what's implicated here between common law and civil law, especially in legal education for law students, maybe something you can kind of mask over when you're training the professionals, but at that fundamental level when they're in legal education, what are the implications of an oral adversarial system on the different ways that law is looked at? Number two, for me, how can you do oral advocacy without an understanding of what the judges are, how the judges are going to weigh the evidence? That's still out there. That still hasn't been decided. But for us to teach about oral adversarial justice without an understanding of how the judges are going to weigh the evidence is a very difficult process. Number three, if the court is the place where you also resolve fundamental search and seizure issues, issues of what evidence is admitted and is not admitted, the lawyer, to be a good oral advocate, is going to need to be prepared on those issues. And the courses are going to have to really prepare them to be able to deal with it. And are they going to be sorted out before trial? Or are they going to be still alive in the court itself? That seems to me to be a real challenge for us as educators thinking about how do we design a program that's going to prepare the lawyers. Is there going to be a law in motion part to the exercise? It sounds like to me for lawyers there is a healthy part, especially as you go into specialization, right? How much of the program needs to be spent on pretrial working between prosecutors and police? And can you replicate that in legal education? Can you really get folks an understanding of that in legal education? In the common law system, we use cases to do that. We use cases that are developed, and the courts describe what those relationships are, and we use those as teaching methods. Here, again, if it's not common law based, how are we going to teach that without the police being present when the students are there? How do they learn how to work with the police? Some interesting challenges there. And then evidence code issues. Seems to me we've heard over and over again, and yesterday afternoon, I don't know if you heard, this is the big fix. If you can figure out what your evidence code is going to do with things like character evidence, for example, or information about gangs, you can greatly increase the percentage chances of winning. If I can find out about MS-13, right, then I got a conviction rate that goes up. Well, that's a fundamental evidence issue. And I still haven't heard too much about where evidence law fits in the reforms. And it would be interesting I think for us as partners to start to say, what do we do with that question when we talk about legal education? Is it a cause for us to try to convince the legal educators to have an evidence code that considers issues of confrontation and hearsay and character evidence? Is that part of the judicial reform? Is that something that legal education should be talking about? When you're talking about fundamental different changes about the way you look at the law, those are part of the fundamental questions, or are those really places where the Mexican system is evolving and it may want to keep its own views? We let all hearsay in, the judge makes the decision, okay? But, you know, we have judge trials in the United States too, and yet what we do is we really then have a lot of procedural protections when the judge is both a fact finder and a lawgiver as it relates to the appellate court. Are you going to have the same things, or is it going to be trial de novo at the appellate court level? And again, without knowing about that, we educators are really saying, I don't know how much of making a record about a document is necessary, because I don't know whether there's an appellate issue that's behind this and how it's going to be reviewed. So these are issues, at least that I've heard as we've been talking, that I think and we don't want to do more harm than good, but there are issues that we face together as we're trying to design programs and curriculum that are going to really address the needs in, as we understand, a changing system. A system that's continually changing. So I hope that you will also not be too frustrated with us as we go through our presentations and realize that there's a little bit of we're learning by doing ourselves as we are working together, and that you will at least be partners with us in this process and not too critical, but say, okay, what did you learn and what's working, and can we take from that, and then, you know, what are you learning that's not working? If you can tell us about that too, that'd be very helpful. So, enough said to kind of, I hope, frame some of the discussion as we go along. And Alex, let me now put you on the spot to lead off and tell what we're doing here at Emory.
All right, I'm going to keep this very brief. I just want to give you a quick overview of what our project is, and I'm going to hand it over to the director of our institute at the Universidad Panamericana, Carlos Requena. Our project was based on the creation of an institute, and what we wanted to do was build up this institute as much as we could within the next 3 years with UP's help. What we've done so far, in August of last year, we started co-teaching a class down in Mexico City, comparative criminal law and procedure class. During that time, we started to develop the professors who were going to participate in this program. In April of this year, we brought a group of 7 professors from Universidad Panamericana to Atlanta and had a 2-week training program that included, among others, Professor Alan Snyder from the University of San Diego, who came along. Over the summer, they've continued to work doing their own workshops, preparing for a trial techniques program that began this fall at Universidad Panamericana for the 9th semester law students. In addition to that, in August of this year, we returned to Mexico City and ran a 2-week program. Once again, we're very lucky to have Professor Alan Snyder participate. These guys are off and running. In the next 2 years, Paul and I will continue to work with them in some capacity. We'll go down for 2-week programs in May of the coming 2 years. But they are really doing this on their own at this point. When we went down in August, it was a UP-run program, and we were there as advisors. These guys are teaching the methodology. They're adapting everything to their own system, and With that, I'll hand it off to Carlos so he can tell you a bit more about what the folks at the UP are doing now. Thank you.
Bueno, gracias a todos y simplemente nada más para enmarcar los comentarios de Alex Barney. Primero y a nombre de la Universidad Panamericana, nuestro total agradecimiento y cariño a Paul. Sin duda, Paul, vamos a acompañarnos hasta que esto concrete y seguramente será por muchos años. A Alex y especialmente a Emory por su apoyo. El reto que tiene la Universidad Panamericana es mucho. Y nuestro reto es que, como saben, tenemos en la Panamericana un instituto muy reconocido que se denomina el IPADE, conocido como Instituto Panamericano de Alta Dirección de Empresa. Y hoy en México y en Latinoamérica es la mejor escuela de negocios en México y en Latinoamérica. Tiene 30 años de fundada y ha sido bajo el esfuerzo y una gran metodología de muchos talentos. Ya la Panamericana autorizó la creación, así como tenemos la Escuela de Negocios, ya autorizó la creación de otro instituto que se va a denominar el IPAEP y por sus siglas se entenderá como Instituto Panamericano de Alta Enseñanza del Proceso. Y eso implica que así como el IPADE es una alta dirección de empresa, no cualquier enseñanza de empresa, sino de alta dirección, el reto es dar a México y específicamente a este contexto de la implementación de la reforma, un instituto que se distinga por tener una alta enseñanza del sistema acusatorio. Para muchos parecería como que es un poco elitista, pero de alguna manera no es que lo sea, sino queremos distinguir esa metodología. Por supuesto que vamos a utilizar todos los recursos que Estados Unidos nos puede aportar a través de USAID, a través de HED y específicamente los esfuerzos de la Universidad de Emory. No puedo hablar mucho porque se inaugura formalmente este instituto en febrero. Seguramente vamos a invitarlos a todos. Es un proyecto que queremos compartir con ustedes. El reto que tenemos es el Distrito Federal, que como saben es la ciudad más grande del mundo, con una población muy compleja. Ahí se concentran las principales barras de abogados y evidentemente la masa más activa de abogados litigantes. Y el reto del IPAEP no solamente va a ser la implementación de la reforma penal, sino la reforma de cualquier sistema jurídico que tenga que ver con el sistema acusatorio. Aunque vamos a empezar con la materia penal, pero seguramente iniciaremos rápidamente también con la comercial, la administrativa, la laboral y cualquier otra más adelante. Simplemente les comento que vamos a, sin duda, a estar muy de la mano con todas las universidades para observar los programas, no solamente universitarios, sino los programas, por ejemplo, de la American Bar Association. Alonso, vamos a estar muy en contacto, seguramente aprenderemos de ustedes. Sin duda también vamos a pedir el apoyo y la experiencia de la Management System International. Alejandro, sin duda muy valiosas tus aportaciones. Y en fin, ese es el reto, crear un instituto que empezará formalmente en febrero y van a escuchar seguramente de nosotros en breve. Muchas gracias.
And who will go next of our TIES partners? Who is ready to go? Daniel. He didn't think so.
Pues un agradecimiento muy cordial, muy afectuoso a Alejandro Barney, al profesor Paul Zwier por su generosa invitación. Y desde luego que para nosotros que provenimos de una universidad pública, como es la Universidad Autónoma de Baja California, es sumamente grato participar en este encuentro. En este encuentro que en lo personal me parece muy gratificante porque nos hace advertir que estamos en una etapa que nos permite avisorar un futuro en que el conocimiento mutuo, el conocimiento recíproco, de quienes practicamos el derecho en México y quienes practican el derecho en los Estados Unidos, seguramente arrojará frutos altamente apreciables. Nosotros tenemos claro en la alianza que hemos logrado formar con la Universidad de San Diego, a quien, por cierto, agradecemos la presencia no solo de David Schirk, sino a Allen Snyder, que están aquí con nosotros, y les agradecemos mucho la colaboración que nos han dado desde hace ya tiempo. Pero nos parece que todos estos trabajos nos van a conducir a un sistema jurídico superior al que tenemos desde luego en México y superior también al que tienen los estadounidenses en su país. Nos parece que no se trata solamente de que nosotros los mexicanos aprendamos de los estadounidenses, sino que esto va a enriquecer mucho a ambas partes. La vinculación entre dos sistemas jurídicos tiene que arrojar frutos altamente apreciables para ambos. Los recursos públicos con que se sostiene este programa, aportados vía USAID, finalmente son también recursos públicos que tienen que ser utilizados para el beneficio de un sistema educativo, de la educación jurídica, en beneficio no solo de nosotros, sino de la humanidad. Se trata justamente de mejorar los sistemas de justicia, porque los mexicanos reconocemos plenamente que tenemos un sistema jurídico, especialmente en el ámbito penal, muy represivo, muy abusivo, que deja muy de lado sobre todo a la población más empobrecida del país. Pero tampoco podemos asumir que venimos a copiar literalmente el sistema estadounidense porque nos parece que tampoco es el gran ideal. Habrá que crear un nuevo sistema que supere las deficiencias del sistema estadounidense y supere las deficiencias del sistema que los mexicanos hemos padecido por muchos años. Por eso yo me congratulo mucho de estar aquí con ustedes y de trabajar en una alianza como la que hemos logrado formar en Baja California con la Universidad de San Diego y con las otras alianzas aquí representadas. El hecho de que sea también ya la Universidad Nacional, la UNAM, integrante de una alianza, nos parece altamente benéfico. Hace muchos años, un profesor italiano, Mauro Capelletti, explicó en uno de sus mejores libros el acercamiento entre los dos grandes sistemas, el sistema anglosajón y el sistema romano canónico, y predijo el profesor Capelletti desde la década de los 50 del siglo pasado un nuevo sistema jurídico, y me parece que esto que estamos haciendo ahora contribuye de manera muy eficaz para que eso que Mauro Capelletti anunciaba hace, no sé, en la década de los 50 del siglo pasado, vaya avanzando. Profesor Zwier, muchas gracias. Alejandro, muchas gracias a todos por la invitación, y por supuesto que estaremos participando mucho por parte de la Universidad Autónoma de Baja California, de universidad de la que, por cierto, no estoy solo yo, porque como ustedes lo saben, está la maestra Candelaria Pelayo, que es la artífice dentro de la UABC de toda esta participación que ha tenido la UABC, y el maestro René Rivas, uno de nuestros colaboradores también muy eficaces y siempre dispuestos a apoyar en estos trabajos. Muchas gracias a todos.
Gracias.
So I was thinking about exactly where we are on the Ann Williams scale. Are we a ripple or are we a wave? And I'll tell you, after we're finishing the first year, and we've done all the things that we were agreed to do under our work plan with Manny and with our funders. And my biggest concern at this point is I'm not sure that we're becoming a wave. I think we're still a bunch of ripples. And the reason that I think that is because one of the things that makes waves happen is that the ripples combine. So far, I'm not seeing that. What I see is 5 projects, each working on their own, and I think everybody's doing what they're supposed to do, but we're not getting the cross-fertilization effect or the building effect of combining our work. So, I first am going to ask you to do one thing. Every single person who's involved in actually training people, and I know that that includes Michelle in the back, and it includes Alejandro, and it includes people that are not part of the HED-TIES HED programs directly. I want every one of you to please send me an email with your address. You don't even have to say anything. All you have to do is say, you begged for it, you got it. Okay, my email address is Snyder, A-S-N-Y-D-E-R at San Diego, one word. That's all, and that's not, it just says San Diego, they're combined.
Could put it on the board.
Yeah, oh yeah, I could do that. Efficiency. And the only, reason I'm asking you to do that is I'm not yet sure that there's a combined list of contact information for everyone who came here. If I don't hear from you, I will hunt you down. The reason I'm saying all this is because for the last several months, not quite finished yet, the Trans-Border Institute and David Shirk, who presented earlier today, have been constructing a website that will be devoted solely to exchanging information between programs that are doing this training in Mexico. We're still casting about for the right name, and we don't yet have our URL address, but I know that there's a really neat looking page. And the idea will be on that website, first of all, to create a master calendar so that when you have your work plan for the year and you know when you're going to be doing programs and where you're going to be doing them, we'd really like to have that on the board. One of the things that we can all see is that a week that we schedule a training, there are 2 other really interesting things going on in some other part of the United States or Mexico, and it would have been really helpful for us to have known that before we made our schedule. So the sooner we can start to exchange just the simple calendaring information, the better we'll be. We also are going to attempt to collect on a designated state by state people who we've trained as trainers and the people who have gone to trainings. Now I know for us, we have to send all that information to the USAID office in Mexico City whenever we do a training, but that's not bouncing back to us. So what we'd like to do is when you send that information to Mexico City, to send it on to the web page too, and then also look at it, because I discovered just the other day that there was somebody who's had substantial training as a trainer who happens to live in Calexico, which is exactly where we're doing our trainings, but we didn't know that person existed. So we'd really like to know about things like that, and I would expect you would too. The other part that I'd ask you to, or I want us to exchange, is information about problems. What have you, and I don't mean that in what's wrong with things, I'm talking about training problems. What training materials have you been using? Scan it in, send it to us. We're not going to steal them. If these are copyrighted, then nobody's going to be able to take them without paying for the copyright license. But if nobody knows what the problem is that you've been using, then no one knows to use it. And I think both Michelle and her program, where they've been operating for 10 years doing training, and also Gary King, who set up that sort of very interesting mixed-use program in New Mexico, are examples of the kinds of things we should be looking at. Maybe we can't use them, Maybe we have to adapt them, but those are things that we'd like to know about. And the last thing really is about what are the problems and solutions that you've discovered or that you've run into. For example, we just talked last Friday with one of the criminal judges, one of the 16 criminal judges who are in these beautiful new courtrooms designed to do trials in the new oral methodology. And all they have is the bare bones of a statute to guide them in how to actually run the trials. They are meeting every day. That's what they say. We're meeting every day to try to figure out what to do, and none of us really know. That, for me, when I hear that, I think, we just had a judge from Chihuahua come and talk to us. They've already done these trials. They must have come up with some way to deal with the very problems that you're dealing with. But we don't know what the judges in Chihuahua did. We know the Chihuahua code. We've got that in English and Spanish, but we don't know what the local rules are. We don't know what the conventions are or the customs in the local area, because everybody will be faced with the same problem as the states come online. So I think it would be really useful for us both to be mining that information source in our local area, the people that we're working with, and also getting it onto a website so that we can pass it on to the judges, for example, in another state as they come online, so that they can, they're not necessarily going to follow it, but they at least have something to look at. So my goal is, let's make a wave. And the way to make wave is to use the energy of information to do it. Thanks.
Manuel Caloca.
Hello again. I represent the Tech of Monterrey, Campus Monterrey, and Southwestern Law School in Los Angeles, California. Let me see. I'm gonna talk about a little bit of our partnership. It's a partnership that it has like 4 years now. It began in 2006. This grant included the training of 6 Mexican attorneys at Southwestern Law School in a master program. It was the master in law, focused in trial advocacy. I was one of the first students in that program in 2007. We had 3 NITA courses, 1 in Chihuahua and 2 in Monterrey, and 1 national mock trial competition for law students. It was national. We had 3 regional rounds in northern Mexico, central Mexico, and southern Mexico, with the final round in Monterrey. In mid-2009, this partnership was extended, and these were the objectives of for this extension. The creation of a law center for trial advocacy, something that the Panamericana is doing right now. We call it Centro para el Desarrollo de la Abogacía en el Litigio Oral. It's a law center for trial advocacy, basically. We teach trial advocacy to students, to lawyers, and law professors. We also had 1 Mexican attorney at Southwestern that year, 1 NITA course, and 384 hours of training. We're going to have 2 national mock trial competitions. We already have 1. We're doing instructional videos. We are having an international symposium of trial advocacy and 2 legal workshops for law professors. The NITA course is going to take place in Mexico City next year. The last one was canceled because the insecurity problems in Monterrey. It was already sold. And also the symposium, it was canceled the last month because for the same reasons. Let me tell you, this law center, so I don't know if you have the same purpose, we have to be self-sustainable. We have to charge for our courses. We right now have the support of USAID, but eventually we will have to survive by ourselves, and we need to charge. But right now we are surviving because USAID. This is the website of the CEDALIT. You can find there all of our courses, the seminars, diplomados, workshops, symposium, whatever we have done is in that website. And actually, I had a proposal, but it's the same with the same one of Alan. It's the website containing all the information of all the TIES partnerships. Go back? Yeah. And I believe that we need that information. I would like to know what is doing the people in San Diego, the MSI too. I would like to know what is doing the people in Panamericana and UNAM. And we have our own website, but if we have one website for all of us, it would be great. Like Alan Snyder said. So
David Shirt's website.
Okay, so that's it. That's my presentation. Yeah. Mm-hmm. So, thank you.
Steve. Great. If you right click and check.
My name is Steve Schmidt, and I am a professor at the University of Nebraska, along with my colleague Kevin Ruizer and Doctora Alma Rios Ruiz, represent the UNL-UNAM Rule of Law Partnership. I'm going to talk a little bit about this morning how we became aware of the grant, how we put together our proposal together for that grant, give you some of the specifics of it, and then I'll turn it over to Alma to give you a little more information specifically about what's happening on the ground at UNAM. The USAID grant, I think most everyone here knows, it was to provide higher education support for the legal reform of the Mexican criminal justice system. There were several points of focus for that grant. There are three that we primarily focus on. Updating the curriculum of the law school to address the changes in the criminal justice system, developing continuing legal education for current practitioners and judges through the means of diplomado, and then finally establishing a legal clinic or a clinical course at UNAM for their students where they could actually participate in real cases under the supervision of attorneys while they were still law students. About a month we heard about that grant actually at a reception, a holiday reception in December of 2009, and within a month, myself and a few others from the University of Nebraska were in Mexico City going underneath Nebraska Street, so we took a picture of that. We were fortunate enough to partner with UNAM. We're very pleased to be able to partner with them. As I'm sure most of you know, that's one of the premier universities in Mexico, and it's a very large university, several different satellite campuses. We made contact and visited them to prepare our proposal in January of 2009. We made a second visit prior to being formally awarded our grant. We are I think the babies of the group here because we recently received, it was in July actually, that we were formally received our grant and began work on this project. Our second visit was in June, and again in anticipation of that. During our visits, it was important for us to get a lot of background information because, as you might imagine, we weren't thoroughly familiar with the current criminal justice system in Mexico, with the reform itself, with the way that lawyers were trained or educated in Mexico. So we felt it was important enough for us to go to UNAM to learn some of those things during these visits. Another important thing that we did is we actually visited the local and the federal courtrooms while we were there. Observed portions of some trials, learned a little bit about the role of judges in those trials, and we spoke with a lot of practitioners in Mexico. It was very interesting for me to hear the reactions that Mexican attorneys had in 2009 and compare those with the reactions we had in 2010. I think that there was definitely a change. In 2009, there was a lot of skepticism, a lot of reluctance, a lot of folks saying, we don't think this is going to work, we don't think it's even going to go forward. And by the time we returned in 2010, there'd really been a swing or a shift in those attitudes. And based on that swing and shift, it's just very exciting to be a part of this project. For those of you who have not been in a courtroom in Mexico, this is a courtroom in Mexico City, which is a lot different from the United States courtrooms. Back here is where the accused stands. These actually were two, I think, psychologists talking about the testimony of a rape victim. That gentleman there's the defense attorney. That's the secretary, and then that's actually the hand of the prosecutor for the case. And so they're actually, the secretary is gathering information or explanations, perhaps, of the written affidavits or testimony of those two psychologists about a victim's statement about what had occurred. Different aspects of the proposal that we put forward that was accepted was to assist UNAM in developing their curriculum, to make the necessary changes to prepare their students to practice under this new system, to provide trial advocacy instruction not only for professors who are going to be teaching the system, but also to local practitioners and judges. We do have a portion of our program where Mexican professors come to the United States. There are actually two different types of scholars that we're bringing in. We're bringing in two scholars for a semester each to attend the University of Nebraska College of Law and take law classes in addition to receiving the other education and training. And then also we're having, I think, 3 different groups of 2 professors coming in for 3 weeks, and they're going to be attending either NETA courses or similar courses that we've modified from NETA courses regarding advocacy skills and train the trainer training or teacher training. A number of visits by U.S. professors and practitioners, including taking 3 over the course of the 3-year grant, taking 3 NETA teams down to provide training, skills training for initially Mexican professors and then on to practitioners. We are fortunate enough in Nebraska, we have a NASA grant, and so we have a lot of distance learning technology so that we're actually able to have video teleconferences pretty regularly with the folks at UNAM. We are looking into ways to use that to perhaps conduct some training as well. Right now it's a method for us to coordinate and collaborate. We submitted the proposal back in 2009. We were formally awarded the project in July of 2010. Our first scholars are coming in November to attend. They're actually going to attend 2 NETA courses, advocacy skills and advocacy skills teacher training courses while they are here. And then we return back down to Mexico City for our 3rd visit for 2 weeks in January. Some brief points about our project year by year. The first year, again, we have the curriculum development workshop. We have the 2 Mexican scholars who are attending classes at the University of Nebraska for a semester each. And then we have 2 Mexican scholars attending those NETA courses, Intro to the Adversarial Process. That's going to be some of the training we provide when we return to Mexico City, as well as the pedagogical, techniques training workshop. The second year is when we actually start work on developing and implementing the Diplomado. We're going to have the Diplomado Development Workshop, Intro to Adversarial Process for practitioners. So we're now beginning to start conducting some CLE for practitioners and not just professors. We again will have 2 different UNAM professors come to attend training in the United States. We also have a NETA team that's going to go to UNAM to conduct advocacy skills course there. And then finally, in the 3rd year of our project, that's when we're going to develop the criminal clinic. We're going to have the development workshop, and then by the end of the 3rd year, we're actually going to initiate that criminal clinic. We also do have the repeated process of the 2 Mexican scholars attending those NETA programs or NETA-based programs. And then we have on the 3rd year 2 different NETA teams returning to UNAM to conduct training there as well. And that is an overview of our project. It's wonderful to be a part of this project. I think there are tremendously important things happening in Mexico, and I am very proud and humbled to be a part of that project. And thank you so much, Emory University, for hosting this. It's been a tremendously beneficial seminar for all of us. And with that, I'll turn it over to Alma. You want me to open all of these, don't you?
Bien, pues, buenos días. Primero queremos agradecer la atenta invitación que tuvo a bien realizar a la Universidad Nacional Autónoma de México, a Paul Zwier y en particular a Alex Barney por todas sus finas atenciones brindadas en estos 3 días. Como es sabido de todos nosotros, durante estos días hemos trabajado la importancia y la necesidad de realizar una reforma sustancial en materia penal, toda vez que, como es sabido, el sistema lo requiere. En particular, hacer algunas reflexiones sobre la enseñanza del derecho penal. ¿Cómo estamos formando nuestros cuadros de abogados o cómo deseamos formarlos en la Universidad Nacional Autónoma de México? Tomamos 3 ejes centrales para definir el proyecto que tenemos en la alianza con la Universidad de Nebraska. El primero fue a partir de la adaptación legislativa. Obviamente, la adaptación legislativa se dio basada en la reforma al marco constitucional, lo que significó lograr ya por el constituyente permanente la homogeneidad a nivel federal y en su momento a nivel estatal. Quedando pendiente, como es sabido de todos nosotros, el Código Federal de Procedimientos Penales para regular de esta manera los mecanismos prácticos en materia de juicios orales. La segunda línea fue la adaptación de la infraestructura. Otro desafío que presenta obviamente el modelo en materia penal. Al menos en la Facultad de Derecho hemos construido 2 salas de juicios orales que nos permitirán enfocar a nuestros estudiantes en la práctica haciendo simulaciones de juicios. La oralidad obviamente requiere una capacitación extrema en cuanto a la argumentación, a la estructura lógica del pensamiento. Por ende, la formación de estudiantes que tenemos en la Facultad de Derecho se basa en el problema que ya se manejó en otras sesiones, es decir, venimos de una tradición romano-canónica germánica, donde precisamente nos hacemos en las universidades y no tenemos la facilidad de incursionar en los tribunales, en las cortes. Esto implica un reto muy grande para nosotros, toda vez que la Facultad de Derecho, como todas las demás enseñanzas de escuelas de enseñanza del derecho, tenemos el mismo problema. Con la Universidad de Nebraska hemos podido lograr una reforma al plan de estudio donde se contemple la materia de juicios orales en materia penal exclusivamente y también tenemos en derecho privado que es en materia civil. Recordemos que la Facultad de Derecho cuenta aproximadamente con una matrícula estudiantil de 8,606 alumnos en lo que refiere a la enseñanza tradicional, o sea, al sistema escolarizado. En lo que alude al sistema de educación abierta y educación a distancia, contamos aproximadamente con 4,118 alumnos, teniendo 7 sedes alrededor de la República: Oaxaca, Tlaxcala, Hidalgo, Chimalhuacán, Ecatepec, Toluca, en el Estado de México, y una sede virtual que recluta a 600 alumnos en el Distrito Federal. Entonces, estamos hablando de una cantidad de 12,724 alumnos exclusivamente en lo que refiere a la Facultad de Derecho Ciudad Universitaria, sin tomar en cuenta las otras escuelas de Derecho como son las FES de Acatlán y Aragón. Entonces, en este orden de ideas, pues nosotros tuvimos la necesidad de reformar el plan de estudios. El plan de estudios actualmente permitirá al egresado salir con el grado de licenciado en Derecho y a la vez con el grado de especialista, dentro de las 26 especialidades que tiene nuestra división de estudios de posgrado. Entre las especialidades, obviamente, está la de especialista en Derecho Penal, haciéndolo más hábil en el sistema acusatorio y dándole más herramientas para que nuestro egresado sea altamente competitivo. Tenemos también firmado con la Defensoría de Oficio del Fuero Federal, el Instituto de Defensoría de Oficio del Poder Judicial de la Federación, un convenio. Este convenio permite que nuestros alumnos se puedan titular bajo la modalidad de experiencia y o práctica profesional, tomando precisamente en cuenta los casos reales, apoyando a los abogados que están dando la Defensoría de Oficio. Que ustedes saben, ellos llegan por concurso en el ámbito federal y por ende estamos hablando de excelentes abogados postulantes. Tenemos además algunos cursos de inmersión donde nos vamos a apoyar en nuestras 4 sedes, Los Ángeles, San Antonio, Chicago y en particular Quebec. Ya hicimos un curso de inmersión en Los Ángeles donde estuvimos visitando cortes criminales, cortes migratorias, familiares y una visita a los centros de deportación. Entonces, le permite al alumno desde su temprana edad, desde su temprana formación, tener una visualización de lo que es un procedimiento oral, contando, insisto, con esta infraestructura que tenemos en nuestras sedes foráneas. Todas estas acciones en conjunto con nuestro consorcio de Nebraska consideramos que serán adecuados para poder llevar a cabo la implementación de la reforma penal. Brevemente quiero abrir la materia de juicios orales. Este plan de estudios es muy importante para nosotros porque, insisto, nuestros abogados contarán con 2 cédulas y 2 títulos, la cédula de licenciado en Derecho y la cédula de especialista en las 26 ramas. La Facultad de Derecho, dentro de sus especialidades, que son muy variadas, contempla la materia de penal, ahorita le vemos, de derecho a la información, responsabilidad de servidores públicos, etcétera, pero incluso de menores infractores, también tenemos ya una especialidad. Estamos hablando de 26 especialidades que ofrece nuestra Facultad de Derecho. El plan de estudios, bueno, aquí está, el nuevo plan de estudios, si ustedes observan, contempla en el primer semestre varias materias, la teoría de la ley penal y del delito, en el tercer semestre delitos en particular, en el quinto semestre tenemos derecho procesal penal, en el sexto semestre no contemplamos ninguna, en el séptimo derecho penal 2, procesal penal, y la que nos interesa en el cuarto semestre, juicios orales. Esta materia de juicios orales, como podrán ustedes observar, juicios orales, tiene todo desarrollado el sistema inquisitivo, el sistema acusatorio, algunos aspectos del sistema híbrido, mixto, sus diferencias, y además aspectos de argumentación y estructura lógica del pensamiento. Pues consideramos que con este consorcio, con nuestros colegas de la Universidad de Nebraska, podemos capacitar, formar nuestros cuadros de estudiantes que permitan enfrentar los problemas que requieren desde el punto de vista de la abogacía el siglo XXI. Muchas gracias.
Is, help me, is Popovich?
Popovich, yes.
Popovich, Ms.
Lubica Popovich.
Muchas gracias.
Thank you. Well, first, you listen. Second, you learn. Third, you question. Fourth, you actually do it. And then the fifth, you teach it. Okay? That's our motto. I didn't make it up. It comes from a famous quote, but it's our motto. I'm here from Illinois Institute of Technology, Chicago-Kent Law School, and I'm here as a representative of Judge David Erickson, who is our director of the Trial Advocacy Program. We became involved in the HED-TIES program in 2009, and last year in June, we had an opportunity to go to Tec de Monterrey in Mexico City and put this program together. One of our biggest challenges is what Alan talked about. We didn't know what everyone else was doing. So what we did is we took what we teach in Trial Advocacy 1 and what we teach in Intensive Trial Advocacy, and we put it together. What I've heard here today is a discussion of a toolbox, the toolbox being the reform that has happened. What we wanted to bring and what we were asked to do is bring the tools. So my discussion will be brief, but it's also very practical. What do you do in an oral system? What is a direct examination? Those are specific skills. My belief is that these skills are very teachable. Some come and have more of an innate skill of how to do it. And we certainly saw that at Tec de Monterrey. We said, stand up, do a direct examination. And it came instantly almost. And all we needed to do was tweak it a little and say, you know, maybe this would work better, maybe that would work better. Some were petrified. They wanted to talk about the reform. They wanted to talk about criminal justice. There is a perfectly appropriate place for that. It's not in a trial advocacy class. And that's kind of what we needed to pull out of people. You know, don't talk about it now. Please stand up and do it. Do a direct examination, and then do a cross-examination. This is how you can do an opening statement. This is how you do a closing argument. Those are four components, four major components in any oral advocacy system, not just the American. We would be very egotistical if we took that as just our system. It's not. It's any oral advocacy system. It has certain elements that apply across the board. Now, you will take that and you will tweak it to fit your system and your judges and your courtroom, certainly. But these are the basic skills, the toolbox that we used. Some of the challenges we ran into are all the things that we talked about for the last 3 days. Evidence, pretrial techniques, weighing evidence, what credibility versus admissibility, prejudicial impact of certain evidence versus substantial prejudicial impact of certain evidence. All of that was, we kind of learned it as we were doing it too, because it was a trial and error process. As we were teaching, we were training the trainers, so we were teaching professors who will then teach this in turn. They were coming to us and telling us, well, we don't really have the rules of evidence. That's fine. We kind of worked around that. This is an evolving system, and there are certain things that will progress naturally. The main crux of it, the very practical application, is that these are certain skills that can and will be learned, but they need to be learned in a trial advocacy setting or oral advocacy, where you get up and you learn by doing, and you do it over and you get criticized and then you do it again, and it's kind of uncomfortable when you first do it because you stand up and you might make a mistake, but it's better to make a mistake in a classroom than make a mistake in front of a judge. Now, the second part of what we did was we had a judicial diplomado. A little bit different, because we had judges that came in and they wanted to know, okay, this is what the practitioners will now do in our courtrooms. What should we be doing? We learned that having a 7-day course to teach trial advocacy and a judicial diplomado was too much. Those are two separate things. One needs to be for the judges, one needs to be for the practitioners, two separate components. So we had more of a dialogue of how could you possibly weigh the evidence? What do you do with rules of evidence? What happens at the appellate level? What are the standards of review? So that was a learning process for us because we didn't really know what to expect. This particular conference has been very informative because I realized that there are lots of different schools that are doing pretty much the same thing. And I absolutely echo what Alan said, and I spoke to Alejandro about coming together and showing each other what are the syllabuses. All of us that went down to Tec de Monterrey were NEDA trained, and we also teach at NEDA. We teach at the law schools, and many of us, like myself, are prosecutors or former prosecutors. We do trials for a living. We also teach as adjunct professors. Finding a group of people that had both of those was challenging in and of itself, let alone people that can travel and teach. Once we kind of put together our curriculum and put together our professors, we realized we're really at a disadvantage because we don't know what the right arm's doing or the left arm's doing. So one of the things I would like to see as well is I'd like to see what the curriculums are from the other schools. I have brought a sample curriculum of what we used last year, and I do have the Spanish version of it as well, so those of you that are interested, you're more than welcome to see it. It literally has what we taught for direct examination. How do you direct your witness? How do you prep your witness? Okay, how do you prep your witness to walk into a courtroom that they've never walked into before and actually tell a story? How do you tell a story in an opening statement and sound interesting where the judge wants to listen to you and give all the facts that the judge needs to hear? On the flip side, how do you control your witness on a cross-examination? It's a very, very specific, very unique skill. It's a skill that sometimes can make a trial or break a trial. Okay, effective cross-examiners know exactly how to get the right information. It's super important in an oral system because it will show whether a witness has motive, interest, bias, credibility. All of that comes out on a cross-examination. There's a specific way to do that. And then how do you give an effective closing argument to your judge, where you take all of the evidence, step before the judge, and say, Judge, this is why you need to find this defendant guilty. Or, Judge, this is why we cannot find him guilty in a criminal setting. So that's kind of what we did. That's part of what is in the syllabus. As I look through it now, there are certain things that we should tweak. At the time, we did it to reflect what was part of a jury trial. Obviously, that's not even something that we need to talk about since you won't be having jury trials. And I anticipate that there's probably other things that maybe won't work for the procedures that you will have in place. You know, there's the substantive law, there's the procedural law, then there's the actual oral advocacy skills that you implement in a courtroom. They intertwine for certain, but they are separate skills. So what I would like to see is afterwards, after you've all had lunch, is to get together and maybe share some of that information, maybe add things onto the calendar. We're going to Santa Fe in November. And again, I'd like to know, is anyone else going in November? Is anyone else going to be in the area? Are there any judges or advocates that have gone through the NEDA training or any training that are in the area already? I mean, there's no point in recreating the wheel since it's already been created. It's just a matter of implementing it. So I'm certainly available to answer any questions afterwards. And thank you, Alex, for having me here, and thank you all for having this wonderful conference, and I look forward to working with you.
Leo, last but not least. All right.
So I realize that I stand between, basically between the freedoms, so I'll try to be very brief and to the point. The partnership that I'm representing is based at UCSD School of Medicine, which in this group probably begs the question, you know, what does medicine have to do with rule of law reform? So briefly, I'm going to give you sort of a 20-second version of you know, what encapsulates a lot of our work. Basically, the kind of problems that we're talking about, drug violence, rule of law, criminal justice management, police management, that has a lot of collateral harm on the society. And what we study is the nexus between the rule of law system and health outcomes. So things that are sort of byproducts of drug trafficking, police violence, and the lack of rule of law. In my case, that's specifically related to HIV and other infectious disease that's transmitted through injection drug use and commercial sex work activities. So looking at these issues, we've basically found that when you have a police force or a judicial system that isn't functioning quite correctly, you essentially create drivers for the HIV epidemic and other infectious disease, as well as drug abuse. So as we proceeded to investigate these factors in the cross-border region, we essentially found that there is essentially a very close empirical connection between policing and criminal justice activities, including incarceration, and what drives the epidemic. And as a way of intervention or public health kind of activities that are focused on prevention, we came to the conclusion that as public health professionals, we have to get involved in training police and essentially creating a rule of law system that promotes public health as well. In the cross-border region especially, which is where UCSD focuses a lot of its research, there's ample empirical evidence that shows policing practices that are that violate human rights and are not only illegal, but they actually drive the epidemic because, for example, if police officers arrest or extort money from people who have, let's say, clean needles, you have a deterrent, a behavioral deterrent for people to engage in safe practices, and that drives the epidemic. Same thing with commercial sex work activity. So as a way of, again, as a way of intervention, it's clear that a lot of the activity on a public health front actually is very closely tied to things like policing reform, criminal justice reform. The rule of law essentially does not only promote the social health of societies, but actually promotes the public health of societies. So our HED-TIES partnership is in some ways very similar to what a lot of you are doing, but is in a lot of ways also different, because we're looking not specifically at legal education, but the education of empirical scholars who can investigate drug-related harms, and specifically focusing on this nexus between human rights, criminal justice, and public health. We are working with, this actually I should say is building on a previous HED-TIES program that was a diplomato that trained people on substance abuse and human rights research in COLF campuses in Tijuana, and we've expanded it to include also Ciudad Juarez, and we're working with a variety of NGO partners in those locations, as well as expanding our partnership to police academies and institutions that train police officers as well as correctional officers to promote the idea that what they do influences public health. But of course, if you approach a police officer and with the idea that you're going to train them in human rights and public health issues and how they should be more kind to drug users, it's not going to be received very kindly, or at least you're going to be facing a lot of problems on how to communicate their information. So our approach is to actually come to these trainees with a framework of occupational health. So how to protect yourself in the line of duty, and how to address their concerns about working with these high-risk populations. That opens the door to other information, for example, about what the drug policy is, with the new reforms about personal possession in Mexico that just went into effect in August. What we're finding and talking to a lot of our partners is that a lot of police officers haven't received training on what that means and how they should change their practices. So a lot of this training actually will be focused on explaining what the policy is, what the referral process should be that's in the framework of this new law, and what the public health approach to drug use can mean for police. As a way, and all framed in, we want to make your job easier, this is how to deal with this difficult population, this is how to protect yourself from infectious disease as you do your job. So again, as a lot of these other HED-TIES projects, we're formulating a diplomato which actually builds on work that we've done in the past. It's quite an extensive program. It includes scholarships for master's level students, as well as research projects that are specifically focused on drug-related harms and infectious disease in the cross-border region. So this project is focused on, the diplomato especially, is focused on creating very substantial capacity, local capacity to conduct empirical research on drug-related harms and human rights issues in the cross-border region. Police education program is sort of my piece of the pie. It's again, it frames the issues in an occupational safety kind of capsule, and creates sort of a maybe a triad of components. One is the occupational safety piece. One is the public health piece. What are the public health issues that you're dealing with as a police officer who is constantly in contact with these populations, as well as what are the policy and legal underpinnings of your behavior, because a lot of cops just don't really know or understand what the law is. You know, getting them to actually do what we're teaching is another component. We'll be evaluating how the training influences their behavior on the ground, but we believe that the first step is to at least inform the police force about the intricacies of the policy, which often doesn't happen. There's another component, which is building capacity among Mexican journalists to cover drug-related harms and human rights issues in Mexico. Obviously, all of these components bring a lot of challenges given the current situation in Mexico, but we have a lot of expertise within UCSD as well as among our partners in training journalists and other mass media professionals. So just to reiterate, the idea is to build local capacity to conduct empirical research on drug-related harms, violence, human rights abuse, and to really encapsulate it in sort of a public health or epidemiological view. So really focusing on robust methodologies that can lead to an evidence base that can inform policy down the line, and also can investigate the what I think I mentioned in the first day, essentially the rule of law, or laws as they exist on the books, the policy as stated, and the policies as exist on the ground. And that gap is really one of the primary objectives of our research. To shine the light on what the implementation barriers are. So here's my contact information, as well as information for our PI. This is our working group with some colleagues from Tijuana and Juarez, and I'll take any questions if there's time. Thank you so much. And thanks a lot to USAID, HED, and Emory for having us. This has been an amazing experience.
In a way, I wish that we had his rationale: do it our way or you'll die. You know, in some ways, the educational project, in terms of the reasoning that's out there, the educational piece of it, in some ways, to motivate folks about the change is different. And yet, I think that there are some wonderful opportunities for us to learn about medical health education and how that works, and how that works in that law enforcement setting. So I think this is a good connection for us to keep in mind as we go forward. I want to just say I have been involved in rule of law projects for just about 30 years. I've done rule of law projects all around the world. And I find that there are some similarities, but there are major differences in these kinds of situations where we come and do these things. And it does seem to me that there continues to be this wonderful experience that you've had, and that we've all had, that there's something about a skills-based training that empowers people, that just by itself empowers individuals to be very good advocates in a variety of settings, really independent of the law. And that those are success stories that I think are very, very helpful. It's a methodology, it's a pedagogical style that empowers people to speak. And it's worth doing just in that regard. At the same time, there is, in the international setting, there is this also, the question of could you do skills-based training in a way that also gets at some of these deeper issues, these issues where there's value formation that's going on at the same time. And to that extent, that as opposed to, look, here's how you do it, now do it like I'm doing it, and let me critique you as to how close you are getting, understanding the reasons for it is really essential for people to adopt it. And so in working in Chile, for example, after having worked for many years, and Chileans are coming, it seems to me, I hear our footprint of training the Chileans here when they're coming back and giving their description of what it is that they're now doing. But I'm getting calls today saying, can you come back because it didn't work? And I guess I'm with Alan in the sense of having done this kind of training in a lot of settings. The question is, well, it doesn't really need to be identified with us. I mean, that's not the part of it. It's that in some ways people are finding this learning by doing is also getting at some of these underlying major fundamental changes that are evolving, and provides a forum for folks to talk about those things and to grow and to learn together. And I would say that one of the things I would like is, in particular, for you NEDA people out there, having been a public director of National Institute for Trial Advocacy for 10 years, I have trained lawyers all over the world and used this NEDA method. But the thing that we need to work on together is the rationale when we give critiques. Why? Because especially whenever I've worked cross common law systems and civil systems, that's where the translation gets lost. What parts of controlling of a witness work in the setting that you're in? And why should I lay the foundation for an exhibit a particular way? What makes that more persuasive, more reliable, regardless of the setting in which I'm doing it? And what parts of what's being recommended in front of a jury actually need to be adopted in front of a judge? Those issues, it seems to me, are part of what makes the training useful. And if you are still alive now after this conference with all this information coming at you, if we could get some lunch and if we could maybe combine a couple tables and gather, I would love to have a little conversation now, not formal presentations, where we talk about what some of the folks that have been doing this for a longer period of time are learning about the reasons for, and just the flat-out resistance. I'm sorry, we don't do it that way, and we're not going to do it that way, and we're never going to do it that way. So that we don't get ourselves at cross purposes, so that the Mexicans will call us back in a few years maybe, or call some new group back, or call the people from Yale and say, can you come down here, because those people from Emory and Nebraska and Illinois Institute, they just really didn't help us in what we were doing. So if we can have a little lunch break here, grab some lunch and get together, I think it'd be important for us to try to share information about why some of these skills do work. Thank you all for coming. Thank you all. I know some of you have got to go now at this point, and I don't know about you, but I think we need to give a round of applause to Cedar Ranshaw Nielsen and Mary Ward in particular for their help in this project. If you would join me. And you all have recognized Alex Barney's role in this, and I want to thank him again for all he has done. USAID, HED, I just want to say to you, I hope you feel like what we feel like is our relationships with our partners have evolved even in these last 3 days. It's been a very worthwhile project, and thank you very much for this funding. I think it really makes our projects much more effective and much more meaningful. So thank you again for your support.